said that this is delicate, what President Obama is going to be doing. He's talking about going out to other states and doing public speeches. Is that a mistake? Did you caution him against that?
No, I would not.
We'll take you back live now to the U.S. Senate, where members continue debate on measures aimed at addressing the doubling of student loan interest rates. Lawmakers are now returning from party caucus meetings, and we're expecting to hear from leaders on possible changes to Senate rules concerning the filibuster. Live now to the Senate floor here on C-SPAN 2.
Madam President.
The senator from Florida.
I ask consent the quorum call be lifted.
Without objection.
Madam President, I want to speak about a subject that's on the hearts of most of us now as we approach not what is a coming constitutional crisis, but what is already a constitutional crisis, because this body is not functioning as the Congress, as the Constitution intended. The minority, under the rules of the Senate, is protected and has been. In the early days of the Senate, there was no cutting off of debate. In the early 1900s, a threshold of 67 was established in order to cut off debate. And then after the abuses of that filibuster requirement to cut off debate and the abuses in the civil rights era, indeed, the threshold was lowered to what we have in the Senate rules today, 60. But we are seeing that it is being abused. Under the Constitution, we have the checks and balances of the separate branches, but when a president is elected, the president is entitled to have the people that he wants to advise him to be a part of his team to be confirmed. And it has always been the practice under the Constitution. Not a supermajority vote, as is required for treaties, but a simple majority in the approval of the nominations. But the issue in front of us is whether or not the President will be entitled to have approved by the Senate the people that he has put forth to head the agencies and the department of his administration. And that is what has brought us to the constitutional crisis where we are now finding ourselves ready to act. Congress has failed to put aside political differences to find common sense solutions, not only in the issue of approval of the President's appointments, but on so many of our nation's pressing problems. Let's start out with this charade that we call the sequester. The sequester is a meat cleaver approach to budgeting. I dare say in the minds of most of the senators that it was never intended to go into effect. It was the meat cleaver hanging over the head a year and a half ago of the appointed super committee that after the initial $1 trillion of spending cuts was made on the budget over a 10-year period, which was done, the super committee was to come along and work out deficit reduction of another, with a target somewhere around $4 trillion of total. And what was to encourage the super committee was this meat cleaver hanging over their heads, or guillotine hanging over all the heads that nobody wanted, which was cuts across the board without regard to programs, across the board in discretionary programs, defense and non-defense discretionary programs. And so, such across-the-board budget cuts, is that the way to go about budgeting and making appropriations decisions? Those kind of meat cleaver approaches do real damage to people's everyday lives. And in the long run, the sequester is certainly going to hurt our national defense, our national security, our nation's ability to compete economically with other countries. If we see these kind of cuts in this ideological, without regard to programs, continue, then we're going to be in serious trouble. Now, we can continue to have both sides of the aisle point fingers at each other, but isn't it about time that we get rid of this approach to budget, the sequester, and start talking about how we can get the job done? Well, the ranking member of the Finance Committee is here. He is one of my dear personal friends. I believe he is very sincere, along with the chairman of the committee, the Finance Committee, to really take on tax reform. Are we happy with the tax code that we have? Do we think it has much too much complication? And could not its streamlining, particularly with tax expenditures, which are tax deductions and tax credits, that almost every special interest in the world has their own special tax expenditure? Could we not clear out a lot of them, which produces revenue, and use that revenue in order to lower tax rates and also use some of it to lower the deficit? Well, we need to close some of those loopholes, and I'm hopeful with the leadership of Senator Baucus and Senator Hatch that we're going to be able to do that. But there are a lot of other things in there. It's no surprise that I have been speaking of subsidies that go to companies like oil companies that have outlived their usefulness, that a century ago were given in the tax code as incentives to drill for oil. Do we really think that oil companies need those financial incentives now? What about the offshore tax dodges? I think it's also obvious that when you look at the Medicare drug program, you know that the taxpayers of this country, through their government, got a break on the cost of prescription drugs that we supply to Medicaid and to the Department of Defense and to the Veterans Administration. But when it comes to if you have been getting that price break on your drugs through Medicaid, but you now turn 65 and you get your drugs through Medicare, the U.S. government does not get the break, the discount on the drugs through Medicare. The very same people that were getting them under Medicaid now are getting them by Medicare because they've passed the threshold of age 65. Same drugs, same people. Government is paying it, but the government is paying a much higher price. That could be worth a savings of $140 billion to the U.S. taxpayer over the course of a decade. Now, you do the math on just these few examples that I have given in this short little speech, and it adds up well over $1 trillion. And that's just a starter. And there's hundreds of billions of dollars more that might be saved by closing some of these tax loopholes. I think we need to keep in mind that not all tax deductions are bad. Some serve very legitimate purposes. But here we are, and we come back to the gridlock that we are experiencing. And so we passed a budget resolution in the Budget Committee. It passes out here on the floor of the Senate. The House of Representatives has passed a budget resolution, albeit much different than the one. The normal process around here is to try to work out your differences and to do it, as ladies and gentlemen, with comity. But you know, we can't even get a motion approved here in order to go to a conference committee to work out the differences between the House and the Senate budget resolutions. And so I would continue to plead with our colleagues to allow this to move forward. No less than one of the most stellar members of this body, Senator McCain, has called for the naming of the conference committee. My Republican colleague that helps me lead the Aging Committee, Senator Collins, has called for the naming of the conference committee. So let's do it. Let's end the gridlock on this one little thing. Let's compromise, and let's start using some common sense. If we do, you'll see a chorus of amens from our fellow countrymen. Madam President, I yield the floor.
Madam President.
Senator from Utah.
Madam President, last month I spoke here about the confirmation process and how the majority was committing filibuster fraud. The leaders on the other side of the aisle, including the majority leader and majority whip, voted for judicial filibusters more than 20 times by this point in the previous administration. And they succeeded. There were 5 times as many judicial filibusters at this point during the Bush administration as there have been today. Looking at executive branch nominations, those same Democratic leaders voted to filibuster President Bush's nominees to be Assistant Secretary of Defense and EPA Administrator, and twice voted to filibuster his nominee to be United Nations Ambassador. They must have thought very differently then about whether the President deserves his team. Their actions then spoke more loudly than their words do today about whether they think all nominees really do deserve an up or down vote. The Senate recently confirmed the directors of OMB and the CIA, the U.S. Trade Representatives, the Secretaries of Energy, Interior, Treasury, State, Transportation, and Commerce this year by a collective vote of 816 to 61. That doesn't sound like a Senate that's in jeopardy or trouble. In fact, it doesn't sound like they even have a case to make to do what they have alleged they're going to do. The Congressional Research Service says that the Senate is considering President Obama's executive nominees faster than during President Bush's second term. But none of that is good enough for this majority. They not only want more, but it appears they are willing to get it by any means necessary. According to media reports, the majority leader is being pushed by political interests to use a parliamentary gimmick to limit or abolish filibusters. In other words, his political base, especially big labor, wants him to put short-term partisan politics ahead of the integrity and tradition of the Senate itself, something that I don't believe any prior majority leader would be willing to do or was willing to do. It's simply saying that it is not enough to show how dangerous it is. We're in more trouble than I thought. Thomas Jefferson called the Capitol the first temple to the sovereignty of the American people. The people established our Constitution with its separation of powers. They designed the legislative branch with an action-oriented House and a deliberation-oriented Senate. We call ours a system of government because it includes all of these parts designed to be different and yet to work together. Many people today bemoan the division and conflict in Congress, the partisanship, and on and on. Yes, there will be conflict over the important issues facing our country. Men and women of different perspectives, views, and ideologies and serving different states serve in Congress. But I always thought we should be of one mind about the long-term integrity of the system of our institutions. For more than 2 centuries, the Senate has been designed to play its own particular part in the legislative process. Form follows function, they say, and so our rules reflect our role. For more than 2 centuries, the minority has had some basic rights in this body, including the right to debate. That right has always annoyed the majority, whichever side has been in the majority, and empowered the minority, whichever side is in the minority. I know that from experience, as I have been among the annoyed, just as today I am among the empowered. And the majority knows it too. A decade ago, when they were in the minority, they began for the time using that right to debate to defeat judicial nominees who otherwise would have been confirmed. And now back in the majority, they want to ban the very tools they found so useful just a few years ago. We've all heard the contradictions between what the majority leader is saying today and what he said when he was in the minority trying to protect minority rights. Now that the majority leader is done using the opportunity for extended debate, he wants to make sure no one else can use it. Why? For one simple reason: because they want their way every time. They think they're entitled to it. And the minority be damned. And if they can't get it the old-fashioned way by persuading their colleagues and the American people, then they will simply rig the rules. This short-term power grab, however, will cause long-term damage to the Senate and to the system of government of which it is such a vital part. And don't think just because they say they're limiting it to the executive branch appointments, excluding judges, don't think that that is not going to lead to all kinds of other obnoxious approaches towards the United States Senate. A little dose of history provides a big dose of clarity to this debate. For more than a century, the right to keep debate going belonged to each individual senator. There was no rule at all for ending debate. A single senator could prevent bills from passing by preventing debate from ending. But we've had a rule for ending debate for nearly a century, and today it is easier to end a debate than at any time since the turn of the 19th century. Not the 20th century, the 19th century. Not only that, but the majority is using that rule more effectively today to prevent filibusters than the rule's been used in the past. It's all there in the public record. When we vote to end debate, we prevent a filibuster. And a higher percentage of votes to end debate have succeeded in recent Congresses than in the past. To top it off, just a few months ago, the Senate overwhelmingly adopted 2 new standing orders and 2 new standing rules, giving the majority even more power in considering nominations and legislation. Using the rules to their advantage is not enough for this majority. Gaining even more power through those new orders and rules is not enough. Now, the majority threatens to use a parliamentary maneuver to weaken or abolish the right to debate itself. But as I said, the Senate rules reflect the Senate's role. Changing those rules, especially in the way the majority is talking about, means changing the Senate's role in our system of government. I might add a few partisan victories simply cannot be enough to justify that. The minority leader has faithfully reminded us of the majority leader's past promises not to change the Senate rules or procedures except through the process provided for in the rules. On January 27, 2011, the majority leader said, quote, "I will oppose any effort in this Congress or the next to change the Senate's rules other than through the regular order," unquote. Now, my question is this. When the majority said, "I will oppose," did he really mean, "I will lead"? Madam President, the integrity of this institution and the system of which it is a part should matter more than the politics of the moment. If our commitment to this institution and to keeping our word no longer matter, we will be breaking the trust of the American people and failing in our duty to them. Now, this must not happen. The Senate is a venerable institution. If the majority continues to go down the road they're going down, it's going to be much less venerable, and it's going to be a broken institution. And keep in mind, their decision, if they do choose to do this, will work against them someday. There's no question about that. And it's not a simple matter. I have to say that I'm very concerned because I believe that not only is it wrong what they're trying to do, but it's based upon wrongful premises. When the majority leader says that we have filibustered hundreds of bills, that's totally inaccurate. Especially when the leader calls up a bill, files cloture immediately like we're filibustering when we're not, and then refuses to allow amendments by tying up the tree. Then the only methodology left is to hold up the bill until we can get some reasonable approach towards amendments in the most deliberative body in the world, supposedly. We are fast moving away from being the most deliberative body in the world to one that is just run by the majority, just like the House of Representatives. The Senate has always been the place where liberals can protect their liberal rights and where conservatives can protect their conservative rights, regardless of who's in the majority. And if this changes, it's going to be a whopping change that's going to be for the worst for both sides. But don't think it's just going to be something that helps at this exigent moment. Anybody who thinks that just isn't thinking very clearly. I hope that some of the wiser people on the Democrat side will prevail. Right now, it doesn't look like they will. But I'll tell you this, if we go down the road that the majority leader is talking, this institution is going to be dramatically changed for the worse. With that, Madam President, I yield the floor.
Madam President.
Senator from Tennessee.
Madam President, I thank the senator from Utah for his thoughtful remarks. I've been trying to think of a way to put in context what's at stake here, because the majority leader said in his remarks today, well, we've changed the rules 18 times. It's true, we've changed the rules a lot. But we're not talking about changing the rules of the Senate. We're talking about changing the Senate. That's what the proposal is. Changing the Senate from an institution that protects minority rights by requiring 60 votes on major matters of importance out of 100 instead of a majority of votes. You know, we grow up and we go to first grade and we learn that the majority wins. And we get that ingrained in ourselves as we grow up in America. And it's a good principle. The majority wins. It's a way to resolve disputes and work things out. But from the very beginning of our country, our most thoughtful observers and visitors have looked at our country and said, but a democracy needs some protections for the minority, for people with a minority view. I've mentioned on the floor before that I've been reading John Meacham's book about Thomas Jefferson, about the conversation they had after dinner on February 15, 1798, and Jefferson wrote about what Adams said to him. And Adams said, no republic could ever last which had not a Senate. Trusting the popular assembly for the preservation of our liberties, he said, is unimaginable. Trusting a popular assembly for the preservation of our liberties. What did he mean by that? What he meant by that was that the passions in our country, and they particularly happen that way today because of the internet, can suddenly grow very strong. They happened back at that time in France with the French Revolution, where the population got excited and began to behead people in connection with the French Revolution. So popular passions can run strong. And our founders said, well, we want a House of Representatives that reflects those popular passions, which is why when you go over to the House, they have a Rules Committee, and whoever wins the House by one vote gets 9 of the seats, and whoever loses gets 4 of the seats, to make it clear that the party that has 4 of the seats really doesn't have anything to say about anything. So they can bring it up on Monday and pass it on Tuesday. That's what a popular assembly can do. And so Adams was saying to Jefferson, we need another body. We need a Senate that's not so responsive to the popular passions. And President Adams and President Jefferson said at the beginning of our country that they did not believe a republic could stand without such a Senate. That's what they said then. Our most famous visitor to the United States was Alexis de Tocqueville, a young Frenchman who came in the 1830s. And he wrote a book, Democracy in America, which is probably the best book ever written about democracy in America. And he said in this, that there are 2 great dangers that he saw to our future democracy. This is when it was very young. One was Russia. That was a prescient comment. But the other was the tyranny of the majority. That's what de Tocqueville said. The great danger to our democracy is the tyranny of the majority. That means that a majority can run over you with 1 vote margin. Now, what does that mean today? Let's say you care about abortion rights. Let's say you care about gay rights. Let's say you care about climate change. Let's say you didn't support the war in Iraq. You didn't support the war in Afghanistan. Let's say you don't like government snooping. But the majority does. The majority has a view that's different than your view. So we can run over you. We can run over you. Not in the United States Senate you can't, because you'll have to persuade at least 60. And it'll take some time to do it. And it doesn't always work. And so you have to stop and think about any issue. The House can say, no secret ballot in a union election. They can pass it in a day. It'll come to the Senate, and we'll say, let's think about it. We'll think about it even if the Democrats are in charge and they're in favor of no secret ballot in a union election, because we protect the rights of working men and women across the country who may be in a minority. But we have to stop and think about whether we want to abolish the secret ballot in union elections. So what the majority leader is proposing doing next week is not just changing a rule. He's changing this institution so that whoever has a majority of one can do anything they want to do, anytime they want to do it, and can run over any minority. It doesn't make so much difference, Madam President, that you run over a minority person in the Senate. You know, we're just individuals. But what about the views we represent? What about the views of the farmers in North Dakota, or the mountaineers of Tennessee, or the civil rights workers in Alabama? What about the people in the 70s who opposed the Vietnam War? Majority, run over it. People who are accustomed to being in the minority know the advantage and the importance of having protection of minority rights, and they know, if they've studied American history, that the chief defender of minority rights in the history of our country has been the United States Senate. That's what the majority leader proposes to change. He proposes to make this a place like the House, where a freight train can run through it overnight and change abortion rights, change the war attitude, change civil rights, change environmental policy. One vote can do it. Run the train through the House. Run the train through the Senate. Today it might be a Democratic train. Tomorrow it might be the Tea Party Express. And our friends on the other side might want to think about that. I've got some very creative colleagues over here. I'll bet they could come up with a pretty good agenda of things we'd like to do if we had 51 votes, and we could do it any day. So this is not about a rules change. This is about changing the nature of the Senate that John Adams and Thomas Jefferson and George Washington, the founders of our country, created to be an alternative to a popular assembly, and that every majority leader in our history has in the end supported in this way. So we should not take this lightly, especially if you're an American person who has an unpopular view. If you feel like you're in the minority, if you feel like a majority might not always agree with you, might even run over you, you do not want the United States Senate to suddenly be a place where a freight train can run through it overnight and change your point of view. You may say, well, we've got the president in the White House. Well, you may. You do today. You might not tomorrow. You might not tomorrow. When I came to the Senate 10 years ago, one party had both the Senate and the House and the presidency. Now, what if we were 10 years ago and we could run a freight train through the House and to the Senate and send it down to President Bush? We might say, no state in the country, every state in the country must have a right-to-work law. We believe in right-to-work laws. Why not make that the option instead of not having a right-to-work law? We might say new rules on public unions. We might have different ideas on abortion. We might have different ideas on climate change. And you, if you're in the minority, wouldn't be able to stop us. You wouldn't even be able to slow us down for a good conversation. We could just run right through town. So one half of this body is in its first term. More than half of my Democratic friends have never been in the minority. I've been in the minority in a variety of ways in my lifetime, and I want some protection more than just from the popular assembly that might run through. That is why I said this morning that I hope very much that the Democratic leader will accept the request from those of us on the Republican side for all of us senators to meet together in the old Senate chamber. where we can meet privately, where that we can talk face to face, and we can say, we need to understand how in the world you on the Democratic side could want to change the character of the Senate in this way, when in 2 years you could be on the other side. What would make you so angry that you would want to do that? And if you would say to us, well, you've been filibustering our nominees, we would say to you, I guess you know that none of your nominees have ever been defeated by a filibuster. I guess you know that, except for 2 circuit judges, and you started that because you did 5 of ours. And you'll say, well, you've been delaying our nominations. And we'll say, I hope you know that the Congressional Research Service and the Washington Post say that President Obama's cabinet nominees have been moving through the Senate more rapidly than President Bush's did and that President Clinton's did in their second term. I hope you know that. And you may say, well, but you've been holding people up for years. And we'll say, well, I hope you look at the executive calendar. You know, it's on everybody's desk here. I mean, this is the list of people who can be confirmed in the United States Senate. Now, how do they get on the executive calendar? They come out of committees. Who controls the committees? Democratic majorities. So if there's someone who hasn't been confirmed, put him on the calendar. That's your committee that can do it. And once they get on the calendar, how do they get confirmed? Only one person can do that, the majority leader. All he has to do is I move the nomination of Jacob J. Lew of New York to the United States Governor of International Monetary Fund. He's been on the calendar since April 16, 2013. You may say, well, there's an objection to that. And we'll say, well, so what? The majority leader can bring it up, and under our rules, we can ask for a 60-vote vote on Mr. Lew to the International Monetary Fund. He's already in the administration, so probably that wouldn't happen, but let's say it did. So the majority leader can bring it up on Monday. We would vote on Wednesday. He would get 60 votes, and then he'd be confirmed. And that would take one of the 24 people off this executive calendar. You might say, well, they've been waiting for years. And we might say, wait a minute, I've got it right here. And the one who's been waiting the longest came to the floor February 26, 2013. That's 4 months ago. There's no one who's been waiting longer than 4 months who's been here waiting for us to do something about it. And the only one who could move somebody off this calendar to a vote is the majority leader sitting right over there. So what are you talking about? That's what we would say to you. You must be angry about something else, or you wouldn't be thinking about changing the character of the whole United States Senate, because no one's been denied their seat except by a filibuster except a circuit judge, which you set the rules for that. And there's no one left to confirm except these nominees for the National Labor Relations Board that President Obama made unconstitutionally on January 24th, 2012. The Republican leader said, well, you've got a labor secretary who's controversial. We all concede that, but the majority leader hasn't moved that we have a vote on him. You've got and he's been reported since May. He's been sitting here since May. The majority leader could have brought him up. There's a lady nominated for the Environmental Protection Agency. Bring her up. Let's vote on her. There are a couple of other controversial nominations, but all we have to do is vote. Except on these unconstitutional nominees, what do we do about them? Let's make it clear what happened with the National Labor Relations Board. Where in December 2011, the President sends us 2 nominees to the National Labor Relations Board. That's the way it's supposed to happen. So their papers then come over to the Health, Education, Labor, and Pensions Committee. Senator Hatch used to chair that. I'm on that committee now as ranking member. Before the papers from the White House even got to the committee, the President recessed to appoint them. In other words, he used his power to appoint these persons to the NLRB during a recess when the Senate was in session. How do we know it was in session? It was in session in a pro forma session, which is a device invented by the majority leader, Senator Reid, when George W. Bush was president, to keep President Bush from making recess appointments. Now, President Bush didn't like that, these 3-day pro forma sessions, but he respected it. He said, our founders didn't want a king. They created separation of powers. That means checks and balances. So I'm the president, but I can't do everything because there's Congress over here and there's a Bill of Rights over here. So President Bush said, I don't like what Senator Reid did. He created these pro forma sessions, so I can't make a recess appointment, but I'll respect that. So Senator Reid has a pro forma session when President Obama's in, and President Obama doesn't respect it, appoints two people. They're still there. The Court of Appeals for the District of Columbia has ruled that unconstitutional. So has the Third Circuit Court of Appeals, the two of the highest courts in the land, and they're still there. They're still there making cases unconstitutionally. They've decided 1,031 cases, where all of which will be subject to being vacated if the Supreme Court agrees with the federal courts. Now, we cannot ignore that in the United States Senate if we hope to preserve the principle of checks and balances in the United States. So, Madam President, I mentioned at the beginning I like to read history, and I said this on the Senate floor, and I'll read it again, and then I'll conclude because I know other senators are here. I was reading John Meacham's book about Thomas Jefferson. I mentioned that, and John Adams and Jefferson, and how changing the Senate, not changing the rule, but if you change the Senate rules in this way, that means that the majority on any day, any year could come through and do anything it wants to. It might decide, we don't like the gas in North Dakota, or we don't like the corn in Tennessee. So we're going to change the rules so we can have an advantage that 51 of us can do something about. They could do that on any day. You do it now, do it then. I mentioned that history. I mentioned de Tocqueville's history, but here's the last piece of history I'll mention once more. This is Chapter 7 of Senator Reid's book in 2007. Chapter 7 is entitled The Nuclear Option. I'd just come to the Senate. He talks about me in this chapter. Gives me some credit for the gang that was formed to preserve the Senate at the time when another majority leader was trying to change the character of the Senate. And I see the distinguished majority leader, so I'll defer to his comments, and maybe it's inappropriate for me to read it. So I'll just read it. Peaceable and productive are not two words I would use to describe Washington in 2005. That was Senator Reid writing in 2007. I just couldn't believe that Bill Frist was going to do this. This is Harry Reid talking. The storm had been gathering all year, and word from conservative columnists and in conservative circles was that Senator Frist of Tennessee, who was the majority leader, had decided to pursue a rules change that would kill the filibuster for judicial nominations. This is Senator Reid's book. It's an excellent book, and I appreciate being mentioned in it. And once you open that Pandora's box, Senator Reid wrote, it's just a matter of time before a Senate leader who couldn't get his way on something moved to eliminate the filibuster for regular business as well, and that, simply put, would be the end of the United States Senate. I believe that. I believe it would be. It's not a mere rules change. Anytime this body changes its rules in the middle of a session without following the 67-vote rules requirement, anytime it does that, doesn't matter what it's for, it can do it again for a matter of precedent. So if it does it for judicial nominations, the importance of the change is not whether or not it's a good idea to have up or down vote on judicial nominations. The importance of the change is that with 51 votes, you can do anything you want, anytime. And that, in de Tocqueville's words, in his foresight, his prescience in the 1830s, takes away from the people of the United States their greatest protection of their liberties, because it encourages the tyranny of the majority. I thank the President. I yield the floor.
President.
The Assistant Majority Leader.
Madam President, I greatly respect the Senator from Tennessee. He's my friend. We've worked on things together successfully, and I hope we will in the future. But I would take exception to his conclusions about this current status of the Senate. 15th year, I've seen this institution change dramatically in 17 years. We have faced more gridlock, more wasted time than I ever imagined could occur in this great institution. It has become commonplace for us to face filibuster after filibuster after filibuster. People at home who turn on C-SPAN to watch the Senate chamber have to get close to their television screens and look and see if there's any evidence of life on the floor of the United States Senate. Are those people actually moving? Are they awake? We go on for 30 hours at a time doing nothing around here. Why? Because we are facing a record number of filibusters from the other side of the aisle. Time and again, when we have important issues to come up, they get ground to a halt for 30-hour periods of time. We're lucky to do one or two things of substance a week. Oh, there are exceptions. A couple weeks ago, we did an immigration bill. I thought it was one of our better moments, but it was a rare moment in the Senate. Too often now, we're facing the filibusters on the president's nominees. Make no mistake, President Barack Obama won the election on November 6th last year. Some on the other side of the aisle are in complete denial of that reality. And winning that election, this president has a responsibility to lead this nation. He wants to put together a team to lead. He brings the names to the Senate for confirmation. Time and again, they are facing filibusters from the Republican side of the aisle. There's one that even precedes the last election. Richard Cordray, who was Attorney General of the state of Ohio, an extraordinarily gifted public servant who was chosen by President Obama to head up the Consumer Financial Protection Bureau. This is the only Consumer Protection Bureau in the federal government. It's an important agency. We created it with the Dodd-Frank Financial Disclosure Reform Bill. For more than 2 years, Mr. Cordray's nomination has been held on the floor of the United States Senate by the Republican minority. That is unacceptable, and it's fundamentally unfair. No one has ever raised a question about his competence or about his integrity, and yet they will not approve him because they don't like the notion of a consumer protection agency. That's it. So to stop the agency from functioning, they're going to stop this appointment by President Obama for 2 years. The National Labor Relations Board sits down in judgment of labor practices across America for the safety of our workers, organization of workers. It's an important agency. But in the words of former Senator Dale Bumpers, there are some on the other side of the aisle who hate the National Labor Relations Board like the devil hates holy water. They don't want to see it exist. But they can't abolish it. They know that. So they stop it from having a functioning majority. They stop nominees that the President submits to fill the vacancies at the National Labor Relations Board. Time and time again. The same thing is true when it comes to the Alcohol, Tobacco, and Firearms Bureau as well. This is an agency opposed by many in the gun lobby. And so since the time that we have said that agency shall be filled by senatorial appointment, there has never been a person appointed. It is the approach on the other side of the aisle to stop agencies from doing their work. This has to come to an end. I don't want to see this happen in the Senate, this confrontation over rules, but I don't want to see the current situation continue either. Earlier this year, Senator Harry Reid, the majority leader from Nevada, met with the Republican leaders, sat down and worked out a bipartisan agreement to try to avoid what we're facing right now. He was criticized by many Democrats who said, come on, Harry, they're just leading you along. They're not going to work with you. You'll find out if you don't change the rules of the Senate, you're not going to get the job done. But Harry Reid said, I'd rather try to do it on a bipartisan basis by agreement. He made that effort, and it didn't work. Today, we find ourselves in this situation with key executive appointments being stalled and held up. Listen to this. Gina McCarthy. Gina McCarthy was nominated by President Obama to head the Environmental Protection Agency. Well, what's her background? Her background was serving as head of the EPA in the state of Massachusetts, the state of the presiding officer, under Governor Romney. She was Governor Romney's cabinet official for the EPA in Massachusetts. She not only has credentials, she's clearly bipartisan in her approach, and so her name came before the regular Senate process. What did the other side do? They submitted a few questions for her to answer. No, not just a few. They broke all the Senate records. They gave her a list of 1,100 questions to answer before they would consider her nomination. That's what we're up against. Clearly tactics to delay and stall even good people from serving. holds on nominees that go on indefinitely. These sorts of things have got to come to an end. If we're going to end the obstruction in this Senate, if we are going to give to the President the power and the authority to lead this nation as he was elected to do, the Senate can no longer stand as a blockade and obstruction to that exercise of authority granted to the President by the people of the United States of America. That is what this is about. A number of my Republican colleagues have reached out to me in the last few days saying, is there a way to avoid this? There is. There is. If we come to the point where we can sit down and work this out together, resolve these nominees, all the better. It would be a good day for the Senate if it can be achieved. But the notion that we're going to walk away from these presidential nominees or other key nominees in the future isn't fair. I invite my Republican colleagues to vote no if they disapprove of the President's nominees. That's their right and it's their duty. But to stop the Senate from even coming to a vote on these nominees, it's just gone on for way too long. I urge my colleagues to try to find some way to resolve this issue, but if we can't, let's end the obstruction in the Senate, make sure the rules reflect the reality that a President should have the executive appointments he needs to lead this nation. Madam President, I yield the floor and suggest the absence of a quorum.
The clerk will call the roll.
Mr. Alexander.
In regard to the filibuster, what's the big deal? We've approved 199 judges, disapproved 2. So what's the big deal? We have 3 judges on the calendar that can be brought up any time. That's not much, and they can be brought up any time. So what's the big deal on a filibuster? We got 82 vacancies in the courts. 53 nominees aren't up here from the White House. So the big deal about not approving filling these vacancies is obviously something's wrong down at the White House that they aren't sending up the nominees. I've got a quote here that you've heard so many times, but I think it's very good. The nuclear option was the most important issue I'd ever worked on in my entire career because if that had gone forward, it would have destroyed the Senate as we know it. Majority Leader Reid, March 2009. That's a pretty big deal, what we're in, because it involves the checks and balances of government. And basically what you're doing is destroying the Constitution if we go ahead with this, if it destroys the checks and balances that the Senate is the only institution in our political system where minority views are protected.
I'd like to say 2 things, one about what's really at stake here and 2 about the claim that Republicans are somehow slowing things down. This isn't about a change of rules. It's about changing the Senate, changing its character. Most of the founders of our country did not want a king, so they created a Congress to check an imperial presidency. And the best known power of the United States Senate is probably the power of advice and consent in Article 2. It means that the president, who is not a king, has to be checked in his nomination of about 1,000 of the major appointees of government. As Senator McConnell said this morning, advise and consent doesn't mean sit down and shut up. It usually means ask a lot of questions. The Democrats asked so many questions to Attorney General Ed Meese when President Reagan nominated him to be Attorney General. It took a year for him to be confirmed. They asked so many questions of me when I was nominated to be Education Secretary for President Bush. It took 87 days. I didn't necessarily like it, but that was the right of the Senate. What's at stake here is not just a change of the rule. It's the way the rule is being changed. What it means is that with 51 votes, any majority can do anything it wants on any day in the United States Senate. It can change abortion rights. It can change civil rights. It can change environmental laws. It can change labor laws. Today, the House can do that. And when it comes to the Senate, we stop and think and consider it. But after this, whoever has the majority can do anything it wants on any day. That is a dangerous trend. It is what Washington and Jefferson and Adams feared. It's what de Tocqueville said was one of the two greatest dangers he saw to our democracy, the tyranny of the majority. Changing the character of the Senate is encouraging the tyranny of the majority, if anyone has a deep understanding of American history. And finally, this claim that somehow Republicans are delaying. The number of cabinet members whose seats have been denied by filibusters is 0. The number of district judges who have not gotten their seats by filibuster is 0. The number of sub-cabinet members is 0. The number of judges, circuit judges, is 2 because the Democrats denied 5 of the Republican judges under President Bush. As far as delay, the Washington Post and Congressional Research Service say that President Bush's nominees are being considered, President Obama's nominees are being considered more rapidly than President Bush's and President Clinton's. And as far as nominees, this is called the executive calendar. There are just 24 names on it. They all come out of Democratic committees. That's the only way they can get here. The only way they can get to the floor if Senator Reid brings them up. He could bring them all up tomorrow. And the one that's been on there the longest came February 26, 2013. That's just 4 months ago. So I challenge the news media to look into these questions about delay. If there's 0 seats lost by filibuster, if President Obama's nominees are moving through as fast as the last 3 presidents, then what's behind this attempt to change the character of the Senate and deny Americans who are in the minority their rights?
Well, the facts that Senator Alexander just put out there make it very clear that this is nothing more than a power grab. Nothing more, nothing less. That's precisely what it is. The Democrats here in Washington want to run roughshod over the minority. And we've seen that. We've seen the president doesn't like dealing with the minority party here in Washington. Whether it's the IRS or the EPA or the CFPB, he's got a lot of agencies that are trying to usurp the powers, the separation of powers, things that are traditionally conferred on the legislative branch of the government, and trying to essentially legislate by executive order. We've seen that over and over and over again. That's been the pattern. And what the majority Democrats are talking about doing here in the United States Senate is essentially running over the rights of the minority. And Senator Alexander said it absolutely right. If you look at there is no basis or foundation on which to change the rules. You look at the executive branch nominees, and he said there haven't been any of them that denied confirmation in the second term, or for that matter before that, but the votes have been big. And Department of Energy was 97-0.
Senator from Texas.
I'd ask unanimous consent that the quorum call be rescinded.
Without objection.
Madam President, I know we have been talking about the nominations process here on the floor and in caucus meetings, but I think it's worth reviewing the facts and compare President Obama's nominees to how nominees of President Clinton and President George W. Bush have been treated, because I think there's broad misunderstanding, and of course, when you don't know what the facts are, or if the facts that you truly believe in are wrong, then you're going to reach the wrong conclusion. And I think a fair look at the facts will demonstrate that President Obama and his nominees have been treated more than fairly. As a matter of fact, 1,560 nominees of President Obama have been confirmed. And during the 4.5 years he's been president, 4 have been rejected. That's not a bad ratio, 1,560 to 4. And when you start looking at how long it's taken for the president's cabinet nominees to be confirmed, well, President Obama's cabinet nominees have waited on average about 51 days. 51 days from the time they were nominated till the time they were confirmed. For President George W. Bush, it was 52 days, and for President Bill Clinton, it was 55 days. So certainly, President Obama has nothing to complain about, at least relative to President George W. Bush and President Clinton, in terms of the amount of time that it's taken for his nominees to be voted on by the Senate. As far as judges are concerned, there have been 199 of President Obama's nominees confirmed to the United States District Court. 199. Only 2 of them have been defeated. That's a 99% success rate, which is pretty good, I think, in anybody's book. President Obama has had 28 appellate judges confirmed since his second inauguration. That compares to 10 under President George W. Bush. I beg your pardon, I misstated that. That's actually 28 judges at the district court level and at the circuit court level and other Article III courts. But the number is correct, 28 for President Obama, 10 for President George W. Bush at this same point in their presidency. So it is astonishing to me, in light of these facts, and someone once said that facts are stubborn things, but if you acknowledge the facts, it's hard for me to understand where this sense of outrage and urgency comes from with regard to the President's nominees. Indeed, the President's, our colleagues across the aisle, renewed sense of urgency to change the long-standing rules of the Senate are based either on a misunderstanding of the facts or, I'm sorry to say, willful ignorance is the only other alternative. So this is a manufactured crisis with no grounding in objective reality. That's about the nicest way I can say it. The facts show that President Obama's nominees have moved through the Senate at a pace quicker than his predecessors. So what about the nominees to the National Labor Relations Board? These are a special case because the Circuit Court of Appeals in the District of Columbia found that the President exceeded his constitutional authority to make an appointment to these NLRB positions in a reported opinion from the court. But this is really important. It wasn't because Congress or the Senate denied the President his choice for these NLRB appointees. In fact, the President nominated them on December the 15th, 2011, right before Christmas. So the President nominated them on December the 15th, right before Christmas in 2011, and the President recess appointed these same nominees on January the 4th, 2012. What was still astonishing about that is the paperwork for the nominations hadn't even made its way over to the Senate, and the Committee of Jurisdiction had not even had an opportunity to have a hearing on these nominees. But in spite of that, the President sought to circumvent the advice and consent function for the Senate that's written in the United States Constitution and make what he called a recess appointment. Another notable fact about that is that the President himself decided, not the Senate, when we were in recess, leaving the Court of Appeals, when they had reviewed this recess appointment and holding them unconstitutional, so there's really no real difference between what the President did in terms of determining the Senate was in recess and deciding to do it while we were breaking for lunch, and held that it was, as I said, not constitutional. So senators were not even given a chance to review his nominees to the National Labor Relations Board, much less block them. After the court ruled these appointments unconstitutional, the President renominated them this past February. They were reported out of the committee in May, and due to the inaction of the Majority Leader, who's essentially the traffic cop for the Senate floor, they haven't even been put up for a vote by the Majority Leader. So this is another really important fact that I think most people don't fully appreciate. If I wanted to propose a nominee, I wouldn't have any standing to do so. It is the Majority Leader of the United States Senate, representing the majority party, who is the one who determines when these nominees will come up for a vote. So to say that somehow it's the minority's fault that these individuals haven't been put up for a vote completely distorts how the Senate operates and is a disingenuous approach, to say the least. Now, we should recall that Republicans and Democrats came to a genuine compromise on the matter of nominations at the beginning of this Congress, and a deal was struck. In exchange for Republican support, the Majority Leader gave his word here on the Senate floor that he would not attempt to change the Senate rules other than through the regular order. And what that means, as the distinguished senator from Kansas knows, the ranking member of the Rules Committee, that means going through the Rules Committee and coming to the floor and 67 votes to change the standing rules of the United States Senate. So the Majority Leader gave his word that he would not try to invoke the so-called nuclear option, which we are now threatened with, but would rather seek to change the rules through the regular order, which would require 67 votes on the Senate floor. Well, now as it turns out, Senator Reid is willing to apparently go back on his word and is now poised to break the rules of the United States Senate in order to get his way, in order to change those rules. Many of our colleagues said when we questioned them about this, why would there be such an extraordinary power grab and breaking of one's word when it comes to how the rules change, wonder, what's the rationale for this? We've gone through the same facts I just described earlier, which show that President Obama's nominees have been treated at least as fairly, or even more fairly, you could argue, than President Clinton and President George W. Bush. And our Democratic colleagues have said, well, this is just a narrow, modest change that would only apply to nominees to positions in this administration. Well, that's not the way the Senate works. If you break the rules in order to change the rules, in this instance, there is a slippery slope, to say the least, to extend this same practice not only to nominations, but or executive nominations, but also federal judges and to ordinary legislation, which would allow the tyranny of the majority and deny the minority an opportunity to influence ordinary legislation or to make sure that its voice was heard when it comes to nominees. So the argument that this is just some sort of narrow fix designed to break some imaginary logjam with regard to this administration's executive nominees is just false. The fact is, if the Majority Leader goes through with this nuclear option, as it's called, he will have set a new precedent in the Senate, one that says it's permissible to break the rules of the Senate at any point in the Congress simply to get your own way, if the majority has the gumption to do it. I hope the Majority Leader is aware of the magnitude of this decision. Even more importantly than that, I hope members of the Democratic caucus understand what this means. I've been here long enough to have been in the majority and been in the minority. I can tell you that being in the majority is a lot more fun. But I can also tell you that majorities and minorities are fleeting. The shoe will be on the other foot, and it's simply short-sighted and I believe an abuse of our process to try to jam these nominees through based on some manufactured and imaginary crisis and change the Senate forever as we know it. I hope the Majority Leader understands that the consequences will forever alter the nature of this institution, and not one based on just the rules, but based on the relationships that are so important to getting anything done here. I mean, we all understand that the rules are important, but fundamentally the way the United States Senate operates, regardless of whether Republicans or Democrats, regardless of where we come from, is your word is your bond. We have to be able to believe it when colleagues across the aisle, no matter what their political differences may be, when they give their word, you have to be able to depend on it. And if you can't depend on your word, and if we can't depend on the Majority Leader's word when he said he won't invoke the nuclear option, well, it forever undermines the important relationships and bonds of trust and confidence that we should be able to have in this institution. Madam President, just to go over a few other short points, according to the Congressional Research Service, the Senate's considering President Obama's executive nominations faster than any other recent president. I've talked about that recently. But here's some of the President's cabinet nominees that have been confirmed recently. The Energy Secretary confirmed 97-0. The only reason we had to vote on it really is because the Majority Leader finally decided to put that nomination on the floor. It was unanimous, 97-0. Everybody who was here voted in favor of that nomination. Secretary of Interior is 87-11. Secretary of Treasury, Jack Lew, 71-26. The Office of Management and Budget, 96-0. The Secretary of State, John Kerry, was confirmed 94-3, and he was confirmed only 7 days after the Senate got his nomination. The Administrator for the Centers of Medicare and Medicaid Services was confirmed 91-7. The Chair of the Securities and Exchange Commission was confirmed by voice vote. There wasn't even a recorded vote. That's essentially a unanimous decision of the Senate. Secretary of Transportation, 100-0. Secretary of Commerce, 97-1. Well, Madam President, it's worth recalling some of the words that were spoken by different members of the Senate, because this is the kind of thing that will come back to haunt you if you flip-flop and take a different position later on. This is Senator Harry Reid, December the 8th, 2006. He said, "As Majority Leader, I intend to run the Senate with respect for the rules and for the minority rights the rules protect. The Senate was established to make sure that minorities are protected. Majorities can always protect themselves, but minorities cannot. That's what the Senate is all about." And then there's the Majority Whip, Senator Durbin. This is April the 15th, 2005. He said, "Those who would attack and destroy the institution of the filibuster are attacking the very force within the Senate that creates compromise and bipartisanship." Well, if that's true, and I agree it is true, why in the world would any senator vote to destroy the very force within the Senate that creates compromise and bipartisanship? Particularly when we're making decisions here that affect 319 million Americans. And then there's the President of the United States when he was in the Senate, April the 13th, 2005. Then Senator Barack Obama said, "If the majority chooses to end the filibuster, if they choose to change the rules and put an end to the Democratic debate, then the fighting, the bitterness, and the gridlock will only get worse." Madam President, I realize that we are passionate about our positions on the various issues that come before the Senate. And that's entirely appropriate. We all have convictions about these important issues. But this is the only place, perhaps left in the country, I believe, where we can actually debate these in an open and responsible way. And we can be held accountable by the people who send us here, in my case, 26 million Texans. But if we're willing to engage in this sort of shifty behavior, if we're willing to break our word in order to get momentary political advantage, then I think the public's confidence in the United States Senate is going to be completely undermined, and we will have lost our effectiveness. And perhaps just as significantly, the very bonds of trust that are so important in order to get things done around here will have been broken. And for what? For a temporary advantage over 5 or 6 or 7 executive nominees. I dare say if Senator Reid had put these nominations on the floor, we would see the vast majority of them confirmed a long time ago. And the only reason why they weren't is because he chose not to do so. And what he's done is to put them on the floor now in this period of time before the August recess and to create a manufactured crisis so he can then invoke the nuclear option and somehow convince members of his own caucus that they ought to be party to breaking the Senate rules in order to gain temporary advantage. It's incredibly short-sighted, and one that I think will exacerbate the gridlock and the divisions here rather than help us try to find ways to build consensus and work together in the best interest of the American people. Madam President, I yield the floor.
Madam President.